Today we are going to take a look at the Johnny 5-0 arrest. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. First, let's discuss some ground rules for this video. As a veteran, I find the use of protesting at Veterans Affairs facilities repulsive. But that is also what makes it effective. Freedom of speech, the free marketplace of ideas, requires that we allow speech that is repulsive. And the counter to repulsive speech is more speech. A person should never be arrested or imprisoned for the content of their speech. Now, I actually disagree with the hate words exception, and with most, if not all, of the exceptions to free speech. That said, freedom of speech is something that I have defended my entire life. Yes, I find the use of the VA as a protest tool repulsive, yet I defend Johnny's right to do so. Second, there is going to be some discussion of legal principles in this video. I'm sorry, I can't take the time to run it all back to the beginning of time or break it down Barney style. We can agree or disagree on what should be. I'm talking about what is. Now, let's talk about Johnny 5-0's VA arrest. Johnny violated Pat's rule number 1. Don't be an asshole. Look, he went out seeking confrontation, and we really shouldn't be surprised that he found it. Let's start with his first contact with law enforcement on that day.
Security over there. I'm gonna go report that woman with the camera. Watch. What's going on? Hey, there was a woman over there taking pictures, and I just wanted to, if you see something, say something. I just want to let you guys know that I saw her over there with a camera, and it looked really suspicious. And I just want you guys to know, you guys are the security professionals here, right? So I want to just hand over the baton to you guys and let you handle it. So I don't know if there's like a sniper on the roof or somewhere that might be able to, but it definitely looked unauthorized for sure. So, I'm sorry? It's not illegal to videotape? Are you sure? When did you find that out? Did you find that out this week?
No, sir.
Didn't it from Nikki Baker?
Who's Nikki Baker, sir?
You tell me.
I don't know.
Okay. You will shortly.
Okay, sir.
What's your name?
It's Officer Rosas.
Officer Rosas?
Sir.
Okay. And you've known that photography is not a crime for some time here?
It's not here.
It's not here? Okay. Cool. Well, it is up at the Sepulveda campus, so.
Okay.
But I'm glad that you guys have had actual proper training and education down here, so I appreciate it. So, thank you.
He approached the officer to make a complaint that someone was taking pictures. Really? Then he used that attempt to complain to create a hostile confrontation with the officer. Why? How does that serve the issue of free speech? The officer was not doing anything that was objectionable. Look, here's the deal. Auditors talk a lot about police officers approaching them without a reason. Turnabout is not fair play. One of the reasons that auditors, let me just phrase that. One of the reasons that what auditors do is so important is because there is a power difference. When you approach the officer and engage in discussion, especially discussion intended to create a confrontation, you are putting your life and liberty at jeopardy. Pat's rule number 2, don't talk to the police. Now look, I'm not recommending taking this to the extreme. If you see a cop out with his family at a local restaurant, the courteous, "Hi, how's it going?" is clearly acceptable. But you should no sooner walk up to a cop in uniform on the street and start talking to them than you would walk up to a strange German shepherd and start scratching his ears. Yes, many times it's going to turn out okay, but sometimes you're going to get bit. After the contact with the officer, Johnny approaches the hospital, and then he draws the attention of a younger officer. Let's take a look at this clip. It starts at 23 minutes and 30 seconds into the video.
They all run adverts. And good, man, I'm live. If you don't want to be on camera, bro, walk away. Walk away now.
So my name's Officer Carr.
Walk away now if you don't want to be on camera. We're live on camera. Just walk away right now. I don't want to hear it later. I don't want to get it privacy. I don't want to hear any of that. So.
Okay, well, hey, sir, look.
Okay.
I don't mind being on camera.
Okay, all right.
First off, my name is Officer Carr.
Okay.
The reason why I'm contacting you is we don't mind you videoing at all.
Okay.
As long as you stay outside.
No, I'm gonna. Okay, then let's. How about this?
Stop. Be advised, he's now walking in the hospital.
Yep. Yep. I'm sorry. What were you saying? I can't come inside.
You cannot.
Now, Officer Carr says, we don't mind you videoing as long as you stay outside. Before the officer finishes his statement, Johnny runs into the building challenging the officer, daring him to do something. You know, the reason this is a problem for Johnny is that he apparently didn't finish reading or understood the CFR that he cites to several times during his video. So here it is, 38 CFR section 1.218. Security and law enforcement VA facilities. Paragraph A is the authority and rules of conduct. The important sentence in the authority paragraph for most users is, the head of the facility is charged with the responsibility for enforcement of these rules and regulations. Lawyers are also going to look up 38 USC 901, but for our purposes today we don't need to do that. We do need to skip ahead to section A5. Disturbances. Quote, conduct on property which creates loud or unusual noise, which unreasonably obstructs the usual use of entrances, foyers, lobbies, corridors, offices, elevators, stairways, or parking lots, which otherwise impedes or disrupts the performance of official duties by government employees, which prevents one from obtaining medical or other services provided on the property in a timely manner, or the use of loud, abusive, or otherwise improper language, or unwarranted loitering, sleeping, or assembly is prohibited. In addition to measures designed to secure voluntary terminations of violations of this paragraph, the head of the facility or designee may cause the issuance of orders for persons who are creating a disturbance to depart the property. Failure to leave the premises when so ordered constitutes a further disturbance within the meaning of this rule, and the offender is subject to arrest and removal from the premises. Okay, let's break this down. Conduct which creates loud or unusual noise. Johnny and Belle got loud. They wanted to create a scene, and they did so. Look, this isn't an attack on Johnny or Belle. You know, maybe they were having a bad day. Maybe they were not in the right frame of mind when they went out auditing. You know, maybe their philosophy of auditing is different than mine. And that's fine. You know, I believe in and subscribe to the journalistic model of auditing. Despite claiming to be news, Johnny appeared to be conducting himself in the activist model. Those two models of auditing cannot coexist in the same auditor on the same audit. Once the auditor crosses into activism, you cannot cross back on that audit. It's kind of like putting instant iced tea in a bottle of water. Either water or iced tea are fine, but once you put the tea powder in the water, you can't take it back out. Once you shift from the journalistic model of auditing to the activistic model of auditing, you cannot go back, at least on that audit. Continuing on. Which obstructs the usual use of entrances, foyers, lobbies, corridors. Look, I know many of you are saying if the police weren't there, the corridor or lobby area would not have been obstructed. I understand. Legally, it doesn't matter. The area was obstructed as a result of Johnny and Belle's conduct, not their mere presence, but their actions and both the volume and tenor of their vocalizations. This is one of the points where we have to talk about what is and not what we might wish it were. The next clause. which otherwise impedes or disrupts the performance of official duties by government employees. Again, I know many of you will say that they did not impede or disrupt the official duties of government employees. And actually, yeah, I think there's a point there. I'm pretty sure it's not the same point as many of you may think. So here's why I say that. Law enforcement's job is to respond to situations that may call for law enforcement. Coming to this event did not impede their jobs. It actually defines their jobs. However, Johnny did demand a supervisor, and both a Leo supervisor and a facility administrator responded. Now, that same argument can be made both ways. This clause is really up in the air as to its applicability against Johnny and Bell. Moving on. Or the use of loud, abusive, or otherwise improper language. Here, Johnny and Bell crossed the line repeatedly. You have to understand the difference in speech. Fuck the police. That is protected political speech. Fuck you, police. Brother, you're going to jail. Johnny and Bell both directed loud and abusive language at law enforcement and at the administrator multiple times. Here are a couple of clips.
You are a judge.
Yeah, can I blow you now too? Can I blow you now too in front of everybody?
Fuck out of my fucking face, bitch.
Fuck you. Fuck your mother, okay? Get out of here.
Oh, take your fucking bullshit logic and go fuck yourself.
Now there is some question as to the viability of the otherwise improper language terms. You know, it's vague, it's a questionable phrase, but I differ from Merb, who questions the constitutionality of this. I think that this clause would survive a facial challenge, as they only have to show that it could be applicable in some situation. As for an applied challenge to that language, you know, the Ninth Circuit addressed this very issue in the past in the United States v. Louis Agrant, Sr. It's case number 13-10218. And I'm not going to get into the details of that case. Feel free to look it up and read it. It's available online. The court held that the statute was not unconstitutionally vague as to disturbances in section 1.218A5. Now, that section has to be read in conjunction with section 1.218B11, the definitions. So, how did this mess happen? Frankly, Johnny and Bell simply did not fully read and understand the regulation. Johnny kept citing to 1.218A10. Photographs for news, advertising, or commercial purposes. Photographs for advertising or commercial purposes may be taken only with the written consent of the head of the facility or designee. Photographs for news purposes may be taken at entrances, lobbies, foyers, or in other places designated by the head of the facility or designee. Specifically, Johnny focused on the second sentence. Photographs for news purposes may be taken at entrances, lobbies, foyers, or, and this is a mighty or in other places designated by the head of the facility or the designee. The designee was on site. Law is about language. You know, maybe in that sentence is permissive. It is not an assurance or a guarantee of a right to photograph there. The or tells us that it could be any of the three places listed or in another location identified by the designee.
Outside.
No, I'm gonna, okay, then let's, how about this?
Now, Johnny didn't wait to hear the rest of what the officer had to say. This could be a division between the activistic and the journalistic auditing models. But personally, I think it's far more likely that there was something going on with Johnny on that day that caused him to be a little excessively confrontational. Now, we need to discuss the second part of this regulation. If the facility administrator or designee gives you an opportunity to terminate the wrongful conduct, and you do not leave, you are subject to arrest and removal. Now here the administrator gave the opportunity to cease the conduct several times. He asked them to leave more than once.
Okay.
You're going to leave now?
Me?
Yes.
For what?
That's not that. You're leaving now?
No, for what?
To tell me why.
For what crime?
You can't just say
For what crime?
Please. You're getting disturbance. Yes, both of you. And
And him, you're
leaving
taking
now?
too?
You're leaving now, or you want me to? That's a choice.
So your reasonable, articulable suspicion of a crime is, please just turn.
Turn around. Put your hands behind your back.
The clips we just watched show the administrator complying with that regulation. Now, folks, you have got to learn and understand the laws. You can approach the line, but don't cross it. Once you cross the line, you're wrong. And that's all anyone is going to care about. You can't affect change when you're wrong. Brings us to patch rule number 3. Learn the laws. Know where that line is. Not where you think it should be. Not where you want it to be, but where it actually is. Then you can make a knowing, intelligent, and voluntary decision to cross that line when you determine the benefits outweigh the risks or costs. It needs to be said that I don't know Johnny and I don't know Belle. I have no reason to like or dislike them personally. And frankly, I have not taken the time to go through his entire prior catalog of audits. I'm responding to the arrest of the VA and the regulation in play only. And I got to tell you, this is the 3rd time I've shot this video. The first time, I spent too much time over-explaining the law involved. Absolutely no one wants to hear a lawyer talk law that much. It isn't even fun law. The second time, I decided to reshoot this because of the allegations of doxing and stalking directed against Belle. You know, folks, there's no call for that type of behavior. It's wrong. It's civilly actionable and criminally actionable in most states and federally. Doxing typically falls under harassment or stalking laws. Now, admittedly, it's not the easiest case to make. It is actually a far more difficult approach to securing a conviction under harassment than most prosecutors would like to attack. But some prosecutors will, and that number is growing. There have also been several attempts to update the laws to reflect the modern internet reality. So please understand that those attacks, and I'm not going to get into the personality conflicts and the fights between personalities on YouTube. I don't think it's appropriate, and I'm not putting myself in that situation. So understand that under my 3rd rule, doxing in and of itself could be actionable, and you need to know what the law is and where the line is. Internet crosses state lines. You need to be aware of not just your law, but federal law, not just your state law, but the federal law, and potentially even the laws of the state where the message is received. Please, don't dox. Don't do it. It's just simply not worth it. Now, I'm going to ask you to like, subscribe, dislike if you hate this video that much, that's fine too. But drop a comment and tell me why. You know, I engage my viewers. I'm happy to chat with you about it and I'd love to discuss it. So I'm not going to go any farther on that, but thank you very much for watching, and we'll see you in the next one.